You are now unmuted.
Hi everyone. Hi Arma, Rachna, Tasil. How are you? Hello. Any one of you have this Transfer of Property Act for your mains as well? Anyone, Rachna? Or you just have it in prelims only? Anyone? Karnataka, I am sure it's only for prelims. Anyone appearing for other states where you have it for mains as well? Rachna, you are also appearing for Karnataka only, right?
Yes,
Karnataka. What about Arma and Tashil? You are appearing for which state? I think mostly for prelims only this paper is there, right? So there are just three things remaining which we will be discussing. One we have is election. Then another we have is marshalling that we will discuss today. Then also related to that, we have another provision, section 82, contribution. So contribution we will do tomorrow. Plus, if we get some more questions on that, MCQs we are already discussing. Whatever topics we are discussing in class, I always try that I get some questions. Today also there are few questions. Apart from that also, if we get any questions, previous year question paper or just MCQs, that I will try to find out. So tomorrow we will be discussing that part. Okay, contribution plus some more questions on whatever topics we have discussed till now. Okay, so today we have two different concepts. One is doctrine of election and another one is marshalling. So what is this doctrine of election? It is given under section 35 of Transfer of Property Act. Okay, so as we know, Transfer of Property Act is divided into different parts, different things are given, right? Different parts, different chapters are there, and under that we have different concepts. First one was preliminary part, which we discussed on our first class also. It's preliminary part, it is talking about name, title of the legislation, where is it applicable, it is giving some definitions also. And not like other legislations, we usually find it in section 2, but for Transfer of Property Act, we get it under this provision, right? We get it under section 3 of the legislation. So section 3 of the legislation, it provides for the interpretation clauses as well. Various definitions are being provided there. And also we have another provision relating to this general clause we have, right? Section 4 of the legislation that says we want to define a certain word, we will always try to see that we would always go back to basically the Indian Contract Act, and whatever definition is given, we would pick from there. Now, this concept that we will discuss today is doctrine of election, that is given under section 35, and it is coming from second chapter of Transfer of Property Act, okay, where we get some general concepts like we get provisions relating to interest, vested and contingent interest, which we discussed. Then we also get some provisions relating to oral transfer, which we discussed. We get provisions relating to rule against perpetuity, that we cannot block the property forever, it has to keep on moving. All those provisions we get in chapter 2, and similarly, this concept of today's discussion, doctrine of election, also we get under section 35 only. Section 35 of the legislation, doctrine of election. Now, what is election? Otherwise, when we use the term, we mostly use it for normal elections, right? It may be your college election for electing the all the other like bodies, right? All the other people who would be taking care of the functioning of the college. In colleges, in schools also we have election. In universities we have election. For a state also we have election. For the center also we have election. What do we do in election? Usually there would be different candidates and we would try to pick the one whom we like, right? Whom we want to be our representative. That is what election, how we use this word in a normal day-to-day life, that election means out of few given options, we pick the one that we like. Similarly, when we elect a person, out of all the candidates who were contesting the election, we basically pick one person whom we like or we want to be our representative. That is nothing but doctrine of election. But now under Transfer of Property Act, what are we electing? Or why is there a need for election? Because it talks about transfer of property. And as we have studied previously, it's always with free consent of the parties. So if I want to buy something, I want to enter into a mortgage deed, lease deed, gift deed, whatever, I'm doing it with my free consent, without anyone forcing me, without any sort of influence or anything. Then why is there a need for me to elect, or what will I elect rather? Right, so this concept is given under section 35 that talks about doctrine of election. Who will elect, what will elect, or why will someone elect something? That is given under, and this is coming under chapter 2, section 35 of the legislation. So in order to understand what is election, we can take help of this illustration. Maybe I can reduce the size of this one. So we can take the help of this illustration. Okay, take for example, there is one person, okay, there are like two persons who decided to open a hotel, okay, or a resort might be. They decided that they will open a resort. And the first thing that they would need for that is a big property, right? They would need a big property in order to start with that business, in order to start with that business. So what they have done is, this woman here, she said that, okay, I know a property, like it's a very beautiful property, very big property, I know, and we can buy that property, right? In that property itself, we can start this business. Okay, we know this certain property, and in that property itself, we can start this business. And accordingly, under a contract, she said that I will be giving this property. Okay, and you can start with this business. So there is this contract between these two persons wherein she said that I know this certain property, and that property you will be getting, and you can start the business there. You can open your resort. All right, so this is the first situation which we have, that under a certain contract, she promised that, okay, I have this property, I'll give it to you. You can start your business. But now she is not having any property, right? It's just these two individuals which we have. This woman, even though she made a promise, she entered into a contract, she is not having any property. So what will she transfer? She is not owner of any property, but rather she knows another person. Okay, she knows another person who is having a very big and beautiful property. So this woman, she knows this another girl who is having this big property. And what she is doing here is she transferred an amount. All right, she transferred an amount, 2 crores to this woman here. She said that you keep this amount. Now this, she will obviously think, right, for what are you giving me this amount? After that, she said that you keep this amount and you give your property to this person, right? The same person with whom she had entered into a contract. But she is not owner of the property. She only knows this certain property, which is a very big and beautiful property. So she gave some amount or a benefit to owner of this property, and she said that you on like in return of that amount or in return of that benefit, you transfer this property or you transfer this house to this person. All right, so this is the given situation which we have, wherein we have three persons or three parties. One is owner of the property, who is having the right to transfer the property in any of the different modes given under TPA, sale, mortgage, whatsoever. It's only the owner who is having this right, not anyone else. But someone else who is not the owner of the house and accordingly not having right to transfer the property, but still she is entering into a contract with someone else that I will give you this property where you can start your business, you can open a resort. So what is happening here? Someone who is not the owner of property plus not having right to transfer, right? She is not even agent or some legal representative or any agent of this person also, right? Whom this right is been given that, okay, you can transfer my property. You can look for a prospective buyer and you can transfer my property. No, that power of attorney is not being given to her, but still she made a promise that I will give you this property. You can start your business there. Okay, so that is the situation which we need, that someone who is not the owner of property plus not having right to transfer the property still enters into a contract or still makes a promise that I will transfer this property to you. Who will be the other person? Definitely, if it's a transfer, the one transferring would be transferor. To whom it is given, that would be transferee. Right? So this transferor makes a promise to the transferee that I will be giving you this property you will be getting. But transferor is not even the owner of property. Transferor is not even having the legal right to transfer the property. Okay, that is the situation which we have. Now, in this given situation, what will she do? Under Indian Contract Act, we have studied that we cannot be like, okay, fine, this is a contract, I will just accept half of it. Where I'm getting benefit, that part I will accept. Where I'm having obligations or liabilities, that part I will ignore. That we cannot do. When we are accepting a contract, it has to be exact mirror image of the offer, right? Acceptance has to be exact mirror image of the offer. That means when we are accepting an offer, we need to accept it as a whole. We cannot accept part of it where we are getting benefit and refuse where we are having obligation. Same rule applies here also, because Indian Contract Act, Transfer of Property Act, all these legislations are related. So here what is happening is she will say, when she is having these two options, right? She has this 2 crores and on the other hand, she is having her property. So she cannot keep both the two things. She cannot be like, okay, give me the money also, but I will not transfer my property. She cannot do it because it's part of one single contract itself that you keep these 2 crores and you transfer your property to the transferee here. So the owner of this property, she will have to accept the whole of this contract if she wants to accept it. Okay, so who will elect here? There are 3 persons. One is transferor giving 2 crores to the owner of property. There is owner of property and there is transferee. When we say this example is relating to doctrine of election, you need to select out of given options who will have this option or who will have the obligation of selecting. It is always the owner of property. Okay, it's always the owner of property who will have the obligation of selecting. That means you cannot take the benefit and then be like, no, I don't want to transfer my property. I never intended to transfer my property. She cannot do it. She will have to accept either one of this. and that is nothing but doctrine of election. Okay, when someone not being owner, not having the right to transfer the property, still makes a contract and promises some other person that I will give you this property. You can start your business. You can reside there. You can enjoy the property, whatever you want to do. But she is not the owner, and hence she is not having right to transfer. If she has entered into such a contract, and after that, in order to execute the contract, what she is doing is she has given some benefit to this owner, original owner of the property. She is giving some benefit that you keep this money, and in return of that, you transfer the property to the transferee, whom I have made a promise. In such a case, just because she entered into a contract, owner of the property is not liable under it, right? Because for a contract to be binding on us, we need to give consent, right? Consensus ad idem. It's only consent that makes the law. Otherwise, some random person saying something, no, we will not be liable, we will not be answerable for it unless and until we are giving our free consent, we are accepting to it. Same will apply here also, that this owner of the property will have to decide whether she wants to retain the property or she wants to keep this benefit or the money that she is getting. But she cannot keep both of those. Like same what happens in an election, we cannot say that, okay, we want all these candidates to be our representative, because more the number of people, more would be the strength of his voice. No, we need to select someone, right? We need to pick the right option. Here also same, you cannot keep both the two things. You need to elect out of the given options, and whatever you elect, that will be binding on you. And just like Indian Contract Act, we cannot say that, okay, we are accepting half of it where we are getting benefit and remaining half we are not accepting. Let it be. That we cannot do. Okay, this is nothing but doctrine of election, which we get under Transfer of Property Act, Chapter 2 of the legislation. Okay, is this example clear? We have some explanations as well.
Yes, madam.
So we have some explanations for this. Okay. Now, election. What is election? As we know, otherwise also we use this word, that election means choosing between two alternative rights. Okay, when we have two or more different rights, we are trying to select between those alternative rights, whether we would want to retain the property or we would want to retain the money. So out of these two alternate options, we need to select one. If two rights are given to a person under any instrument in such a manner that one right is more preferable than the other, he is bound to select or choose only one of them. Both these things are like equal, right? One hand you are getting to retain the property, on another hand you are getting value of the property. So which one do you select? You cannot keep both of this. You need to select either of these alternative options which you have. Either you keep the benefit or you retain your property. That I don't want this contract to be binding on me. I am happy with my contract. Whatever you decide, that will be applicable. Doctrine of election, as we know, under Indian Contract Act, it is given under Section 35. And the same provision also applies on wills. And same provision we also get under Indian Succession Act. Sections are 180 to 190. Okay, now only if you have Indian Succession Act for your prelims or mains for judiciary exam, if you have this in your syllabus, only then this information becomes relevant. Otherwise, they are not going to ask you question on which section of Indian Succession Act this provision is there. Okay, but I saw one question in a previous year question paper, I guess for some state where this legislation is included. So if you have this legislation as part of your syllabus, you can keep this information as well with you, for which we also have one MCQ that we will be discussing. Okay, so it's sections 180 to 190 for Indian Succession Act, and for Transfer of Property Act, section 35, which mentions doctrine of election. Same provision that we need to elect either of the alternate options which we are having at a given moment. Under a same instrument, we cannot say part of it we are accepting, part of it I don't want to be binding on. That would not happen. It states that when a party transfers a property over which he does not hold any right to transfer, and entitled to that transaction is the benefit conferred upon the original owner of property, and such title holder must elect his option to either validate the transfer of property or reject it. So as we have discussed in this example as well, when do we have right to alienate a property? When do we get right to transfer a property? It's only when we are owners of the property, or in other case, someone has given us power of attorney to get the transfer done on behalf of the original owner, or we are representing someone as an agent, we are representing someone as their legal representative. Otherwise, we cannot make a promise on behalf of someone else. We cannot sell someone else's property. So for doctrine of election, it's very essential that this person should not be having right to transfer the property simply because she is not owner of the property. So same thing we are getting here as well. It states that when a party transfers a property, so I have entered into a contract with that man that you will get this property, you can start your business there. But then I don't have right, I do not hold this property, I'm not the owner of the property, or I do not have right to transfer. Even under some power of attorney or something also, I have not got the right that I can take a decision on behalf of that person. But still I'm doing it. And entailed in the transaction is the benefit conferred upon the original owner of property. Under that same promise, I am transferring some benefit to the original owner of the property as well. Such title holder must elect his option to either validate such transfer or to reject it. So in such a case, just because I was not given power of attorney or any agency contract or under anything, I was not given the right. So my decision or my proposal has to be accepted or rejected by the person. Okay, in case of contract also we see, right, when an offer is made, when a proposal is given, the offer is having two options. He can either accept or he can reject the offer. If accepting, it would become a contract, it will be binding. You're accepting as in you are accepting the benefit. In that case, you will have to transfer the property also. But if you are rejecting, then in such a case, you are not bound. But when you are rejecting, it has to be absolutely. You cannot say part I am accepting, part I am rejecting, because otherwise it will not be your acceptance or rejection, but rather it will be counter offer. Okay, so here what happens is this person, original owner of the property, will have to elect whether he wants to validate such a transfer, which was made without his permission, without his approval, without him assigning any rights, or wants to reject it. Whatever is the situation, that will be done by the parties. Okay, so this is the concept which we have, and there is one maxim that we have: elegans contraria non esset audiendus. So person is not to be heard who alleges things contradictory to each other. one person who says two things which are contradictory to each other, that person will not be heard. When you are saying something, it has to be in a certain way. If you are accepting, you accept it. You cannot say that I am taking the benefit, plus after that what I am doing is, after that I am not even transferring the property. That would not happen. It should not be contradictory to each other. If you are accepting, then it obviously you have given consent, right? That okay, fine, I'm okay in transferring the property. So it should not be contradictory what you are doing and what you have said. Basically, this doctrine is universal in nature and is applicable to all Hindus, Muslims, Christians. This doctrine consists of the principle of a person exercising choice out of his own free will to do one thing, and is founded on the equitable doctrine that he who accepts the benefit under an instrument or transaction of its choice must adopt the whole of it. Most of the provisions that we get under Transfer of Property Act, they are drafted in such a way that these principles of justice, equity, and good conscience are nowhere being affected, right? We have seen so many provisions like payment of rent to person under defective title, right? By mistake also, if we are paying rent to someone who is having a defective title, still we are being served equity. Similarly here also, these principles of equity are given priority, right? It will consist of principles that one person, right, exercising out of his own free will to do one thing. You are being given this option after the person makes this contract also. Even after that, it's like a voidable contract, right? You have the option of deciding whether you want to proceed with the transfer, you want to take the benefit, or you want to cancel it out. It's like same thing only, right? It's like a voidable contract itself, that even after the transaction is done, even after the promise is made, you are given sole authority or right to decide for yourself with your free will. So in such a case, we can say that it is based on equitable doctrine. If with your free will at a later stage, you validated the transfer, you said that, okay, I'm okay taking this 2 crores rupees. After that, you cannot refuse to give the property. So this is nothing but equity. That it has to serve, equity has to be served to the parties. That he who accepts the benefit under an instrument or transaction of its choice must adopt the whole of it. If out of your free will, you have validated that contract or whatever agreement was there, right? Whatever agreement that lady had entered into with the man, willing to open a resort, right? So you are basically validating that transaction with your own free will. In such a case, you need to accept the whole of it. You need to validate the entire transaction if you are at all validating it. So it is depending on your own free will only. Or if you are renouncing it, if you want to cancel it out, then in such a case also, you will have to cancel out the entire transaction. Again, this principle was determined in this case, Codrington versus Codrington. It's a 1957 case. So here it was said that if, because you are being given this option, you are also being served equity, same thing is expected out of you. If you, with your own free will, you are accepting it, you need to validate the entire thing. You cannot simply accept half of it. Okay, that is the whole concept of doctrine of election. Okay, now we have certain essentials also. Wherein all is it necessary that original owner of a person will have to elect between two alternate options? When is it necessary, or what are the essential conditions that we need in order to satisfy conditions of this doctrine? Okay, so this essentials are been derived from a case, Hanpati versus Devi Prasad and others, wherein it said that when is election necessary, there are certain conditions which needs to be satisfied, or rather there are certain essential elements which we need for this doctrine of election to be applicable. Like what we have seen in the example, same thing applies here also. You can simply remember that example and you will be able to recall all these essentials and other stuff also. So what are the essentials that we have? First of all, a person having no right to transfer. Like what we saw in the example, initially one lady entered into a contract with another man that I will be giving you this property for you to start your business. But then she was not owner of the property and hence she was not having right to transfer. Okay, so a person having no right to transferring property, that's very important. It should not be some like authorized person. It should not be someone having power of attorney, some legal representatives or stuff, but rather someone having no right to transfer the property. Someone not being the owner of the property is transferring the property. That is the first essential which we have, and that is derived from our first example also, that someone not having a right is transferring the property. After that, that same person or that same lady, what she is doing, must transfer some benefit to the original owner of property. Whoever is the original owner, to her, some benefit is being transferred as part of the same transaction. Obviously, the original owner is not going to transfer her property for free, right? Because without her consent, we anyways cannot do. So when we are doing it with her consent, for her to give consent also, like she also has to get something out of it, right? As part of that, this person is transferring some benefits to the owner of property as part of same transaction. That you keep this money or you keep this benefit and accordingly you transfer your property. Okay, so when we say benefit, right, it can be that she is giving value for the property, or it may be like she can give some alternate property also, right? This property we want because of the location, but we are having another better property in a certain different location. You can take this property. Now you elect between these two properties. Are you happy with your own existing property or you want to get this new property? That can also happen. So we are saying benefit, not just money, it can be anything else also, where the person will have to accept it. Okay, so he must transfer some benefit to the owner of property as part of the same transaction. Under the same transaction, he will also say that, yes, this is the benefit that I am offering, so you can accordingly decide. Thirdly, the owner must elect either to confirm the transferor, to dissent from it. So the owner of the property then will have an obligation. That owner can either say that, okay, I am accepting the benefit, or owner may say that, no, I'm happy with my existing property. So in that case only, the doctrine of election would come, where there is someone not having right, not having the authority to transfer a property, is making a promise to transfer. Secondly, under the same transaction, giving some benefits to the original owner. Thirdly, owner must elect. Owner then comes under an obligation, whether you keep the benefit or you want to retain your own existing property. So these are the essentials which we have, 3 essentials. And in such cases, person will be held liable or bound to elect out of the alternate options. Okay, these are 3 elements that we need to remember. Now, where the owner dissents from the transfer of property, if the owner, like when he had the option of selecting or electing between 2 alternate options, if he said that, no, I don't want this benefit, in such a case, or if he refuses to transfer the property, in such a case, what will happen is he will have to forego the benefit. He cannot retain the benefit. He will have to let go the benefit which was given to him. Because as we know, we cannot accept part of the contract which is giving us benefit. It has to be entire thing that we are accepting. Then the benefit contemplated for him would then go back to the transferor. If he says that, no, I don't want to transfer this property, I'm very happy retaining it, then in such case, whatever benefit was transferred to him, it will go back to the transferor, because it was the transferor who was giving him that benefit with an expectation to get something in return, right? So if the owner refuses to accept the benefit or refuses to transfer the property, in such a case, he will have to let go the benefit also, and those benefits would again return to the transferor as if that transaction never happened. Okay, the same way go back to the transferor. This is what will happen in case it is not being accepted. Okay, there was one for Indian Contract Act, right? There was one case, if you remember, Chinnaya versus Ramaya. So what happened there is, there was a mother who was having a property. Okay, mother being owner of a property, mother was having a sister. Okay, like aunt basically. Okay, sister, mother, and sister. Sister was staying in the same property. Now, when mother was like very old, so she decided that after my death, this property should go to my daughter. But if I transfer the property to my daughter, what will happen to my sister? My sister also needs some amount of maintenance. She is not having any other support. So mother said that, yes, I have this property. When I die, I'm transferring the property to you, my daughter. But you will have an obligation. Like, this is basically a gift. Okay, under a gift, I'm transferring it to you. But you will have an obligation to pay annuity, that is annual maintenance amount, to your aunt. So daughter, what she did is she accepted the contract initially. For a few years she was giving also. Then later on she was like, why should I give maintenance to my aunt? I did not get any benefit from her. I got the property from my mother only. So why should I be giving maintenance to my aunt? So aunt filed a case in court, and court said you cannot accept part of the contract where you are getting benefit, like getting the property in gift, and refusing another part where you had an obligation to maintain your aunt. You cannot do it because it's part of one same document, one same instrument wherein obligation was imposed. So when you accepted that contract, you knew that you are having some obligation also. So you either accept it as a whole or you refuse it completely. Or you can negotiate the terms or conditions, basically like counter offer, right? Offer given to you, you again give counter offer. Finally, you can negotiate and come to a conclusion. But once you are accepting, entire thing has to be accepted. The same thing applies here also. Okay, these are the essentials, and this is what will happen in case the original owner refuses that, okay, fine, I am happy with my own property, I don't need it. Next, mode of election. Okay, different modes, how can we elect it? Election by the owner can either be direct or indirect. Just like how contract can be accepted directly or indirectly, how proposal can be given directly or indirectly. Sometimes we may not even utter a single word, still we are giving an offer. The other person also understands, other person also accepts it without uttering even a single word. That is also allowed, right? So it can be direct, it can be indirect. There is no restriction as such. Indirect election, one just needs to simply communicate about elected choice or option. Though in case of indirect election, the acceptance of benefit by owner is subject to two conditions. So it can be direct election wherein owner is saying that, okay, fine, it's a very good deal. I am okay transferring my property. Either he can properly accept it, or he may say it indirectly also. Okay, without saying anything like directly, without directly accepting it, appreciating the offer, also he can do it. But where will indirect acceptance be valid? Where will indirect election be valid? When the owner is not saying anything directly, but still indirectly it is binding on him. So when is it valid? He has to have knowledge of his responsibility to elect. And there must be proof of knowledge of circumstances which should influence the judgment of a prudent man to make an election. Okay, like I said, that it can be benefit, it may be property, another property that you are getting, or it might be money also. Okay, so if it's some relative of yours who comes to you and be like, okay, keep this amount, maybe you may feel that, okay, might be this person is giving this as a gift, might be it's a wedding gift for me. Okay, might be he is giving you a property, you may think that, okay, fine, maybe it's a gift that has been given, and you have accordingly accepted the gift. But later on, it turns out that this person was willing that you would transfer another property of yours to someone. Those situations should not happen. The person, right, in that case, he cannot say like, oh, it was indirect election. You accepted my gift means you need to transfer your property. That would not happen, right? Because there would be no free consent or free will in that case. So when will indirect election be valid then? It cannot be without your knowledge. Someone is giving you a property just like, okay, you keep it, as if it's a gift, and later on saying that, oh, you need to transfer it. That situation would not happen. So what will happen then? He has to have knowledge of his responsibility to elect. When the benefit is given, the person should also be made aware that this is your obligation. I am giving you this benefit, but it's not for free. I am expecting something in return. You need to transfer your property, your existing property where you are owner, to someone else, right? So that is the first thing, that the owner has to have knowledge of his responsibilities also. That yes, I am responsible. If I am accepting the benefit, I will have some responsibilities also. This instrument, this contract is having two parts, getting a benefit, having an obligation. That knowledge the owner has to have. Secondly, there must be proof of knowledge of circumstances which should influence the judgment of a prudent man to make an election. He should know the other facts also. He should know that why is this benefit given after all? It's because this person, transferor, has already made some promise to another person that property would be given. And based on that, in order to execute that thing, he is giving you the benefit, right? This situation, you should have knowledge that it's a case of election, and hence you have the obligation of electing, whether you would want to keep the benefit or you want to keep your property, right? So this is the thing, that it need not be that directly in very clear words you are accepting, but it's very important that you knew what is expected in return from you. You should know that it's a case of election. It's not a case of simple gift that is given by a person without expecting any consideration in return. But here something is expected in return as well. Right? So if these conditions are present, even indirect election also will be valid. Election shall be presumed when the donee acts in such a manner with the property gifted to him that it becomes impossible to return it to the original owner in its original state. So election shall be presumed to be done. It will be presumed by court that you have elected in such a manner with the property gifted to him that it becomes impossible to return it to the original owner in its original state. Take for example, it was not money which was given, but rather it was another property that was given to the original owner. Transferor said that here is my property, you keep it, and your property, you should gift it to someone, you should give it to someone else. With having this knowledge, original owner, what he is doing is he is making some changes, he is utilizing the property, everything he is doing. Such a thing he has done that it cannot be returned in its original state to the person. In such a case, we would assume that you have elected to retain this property, and that is the reason why you have made so many changes, that it has lost its like original state, right? Like how we study under constitution, basic structure theory, right? You have destroyed the basic structure of this property itself. You have made so much of modification that it is assumed that you have decided to keep this property, right? So it may be direct or it may be in an indirect way also, that election can be done by a person. The person can select or elect between two alternate options. But is it every single time election is necessary? No, there are certain exceptions as well. So what are these exceptions that we have for doctrine of election? First of all, when the owner who is considering the election between retaining property and accepting particular benefit chooses the former, that means when a person selects that, no, I want to keep my property itself, right? If someone says that, no, I want to keep my property only, then whatever other benefits otherwise he is getting, he is not bound to give away all of those. He can retain those other benefits he is getting from other places. Only this benefit that he was getting from the transferor, that he need to return. Other benefits, if from somewhere something is coming, that he can retain with himself. Those benefits would not be affected by this concept of election. Secondly, acceptance of the benefit by original owner shall be deemed to be as election by him to validate the transfer. If you are accepting the benefit, acceptance of the benefit by the original owner is deemed, if you are accepting, it's like understood that you are validating the transfer. That's why you are accepting it. And when you accept it, also it's assumed that you are aware of your responsibilities. At a later stage, you cannot be like, oh, I did not know I should be transferring the property, right? You had the knowledge, accordingly, you had accepted the benefit. So accordingly, you need to do your responsibilities also. When the question comes of you performing a responsibility, that time you cannot try to escape. Thirdly, knowledge of the circumstances can be presumed if the person who gains benefit enjoys it for a period of more than 2 years. If he is enjoying the property, making some changes, modifications and stuff, it would be accepted that you have knowledge and accordingly you are utilizing the property. Because after a certain duration, obviously this transferor is going to tell you, right, his intentions as well. If you are keeping the property, you are keeping the benefit, and you are not even transferring your property, 1 year gone, after that the transferor can remind you that you need to give the property. You have accepted my benefit, you need to give the property, right? So when you cannot delay it forever, that I will be enjoying the benefits also, but when it comes to transferring my own property, wait for a few minutes, I am getting it done. No, that would not happen. You need to perform your obligation as well. Okay, so these are just some exceptions that some cases maybe you don't need to directly elect. It may be presumed from your behavior and other stuff. Then there is this conclusion that obviously, like most of the other provisions under transfer of property act, concept of this election, right? Doctrine of election also is very much essential in order to solve equity, and accordingly provisions we have wherein you cannot claim both the rights. When you are having a right to enjoy the benefit, you will have an obligation to give away your existing property, right? Whatever you already had, you need to give it apart, and then only you can accept it. Everything you cannot give, you will have some obligations as well under the transaction which you have accepted. Okay, so this is all about doctrine of election that we have. Okay, there is one more concept, marshalling, that is given under two different sections. Okay, so we'll discuss that part after a 5 minutes break. Okay, it's 8:02 now. We'll meet at 8:08. Okay, we'll discuss that part.
Madam, before that, one question.
Yeah.
See, what says when transferor, when she wanted the example what we discussed above. Okay, so the transferor, instead of gifting her, and then the owner of the property electing and or opting for this doctrine of election, they could have made a direct sale transaction. So what is the benefit of choosing or having a doctrine of election compared to a regular sale process?
Okay, because it is not done by the original owner, right? It is someone else who was not owner also, who is not having right also. Still he made a promise that I will be giving you this property. If it was a sale, that it would have been done by the normal person only, right? Who is the original owner of the property. He only would have done it. Just because it is someone else who is not having a right, then he needs to negotiate with the owner that you keep this benefit and then you get this property transferred to the other. Or are you asking that why this person only did not buy the property?
Correct.
Okay, so in case he is buying unnecessary expense, right? He will have to buy it, get it registered.
I'm not talking about the business owner. I'm not talking about the person who wants to, who is planning to do a business. I'm talking about the person who is transferring the property, though he's not holding the title of the property. So that person can easily buy it from the owner of the property and then subsequently provide it to the business. Correct?
Yeah, that is what I'm saying. If he is buying the property, that means he will unnecessarily have to get it registered to his name. Then he will again transfer it to the business who is planning to start the business. Right? If he is buying the property, yeah, so that would be like unnecessary, right? Because you don't want to keep the property anyways. You have just made a promise that you would get this property, you can start your business.
Okay, madam, one more question. See, generally in any of the sale agreement, not the sale deed, so in the sale agreement when they are executing, so what they will say, suppose A and B are getting into an execution of a sale agreement. So A is the seller and the B is purchaser. So where there would be saying that, so A should register in the name of B or any other person whom B is requesting. Correct? Suppose you may ask the property to be registered in the name of X. Same way it can be done here also. No. So why the doctrine of election is necessarily, or how it is different from the regular sale transaction?
Yeah, regular sale transaction, in that case, first of all, this person would not make a promise, right? Here, this transferor, right? Transferor is already making a promise that you are getting this property. After that, only he is going to negotiate with the original owner. If it would have been like a regular case of selling, buying the property, then he would have first negotiated with the owner of the property that I am interested to buy it. But yeah, I don't want to get it registered in my name, maybe my wife's name, my friend's name, whoever it is, you get it registered. That could have been done only if this contract was not already existing. Okay, there can be situations where maybe for business purpose or other things, these promises can be done. Okay, maybe they want to start a resort in a partnership thing. Okay, they can make a promise that yes, I am giving you this property, and after that you make me a partner, I will do this. Okay, like there can be situations wherein might be because of some emergency or something, you just make the promise. So what will happen in such case? How do we protect rights of this person also, right? Original owner who was not even involved in the matter, his simply promise was made because he was not involved, right? At first you should have negotiated with the owner whether he is interested to transfer or not. Later on you could have done, but when already you have made the agreement, already you made the contract, later on you are doing this, in such cases this concept would apply, which may depend on a lot of situations. It may be for business purpose, it may be for just a person wanted to start something, he just made a promise. So what will happen in such a case? There can be situations, like different situation, different mindset of people, right? So if someone has done it like first time only he made the contract, in such cases only it would be applicable.
Okay.
Okay.
Okay, madam.
Yeah.
So we will connect back at
That's almost time only.
it's 8:08.
Yeah.
So after 5 minutes.
Okay, sure.
Okay.
You are now unmuted.
So is this concept clear? Doctrine of election. Anyone, any doubts you have?
No, madam. Okay.
Rachna, Arma, Dashil, is it clear? Any confusion you have?
Yes, ma'am. Clear.
So you can remember the sections and stuff, okay? There are few questions as well, which we'll see at the end of this. Now, apart from this, we have another concept that we will be discussing. For that also, we have two examples, okay? These examples are similar and these examples will help you remember the concept, what it's all about. Now, under different modes of alienation or different modes of transfer of property, we have seen that there are different modes of alienation. There is sale, mortgage, lease, so many things are there, right? So this concept that we will discuss now, that is rule of marshalling. It is given under two provisions, like different chapters is talking about different modes of transfers. Right, so under chapter 3, we have provisions relating to sale of immovable property. Under chapter 4, we have provisions relating to mortgage. So many sections for mortgage, 58 to 104. And for sale of immovable property, we have 54 to 57. So in these two chapters, under two different sections, we have concept of marshalling mentioned. Why is it necessary to mention the same concept in two different sections? Because here it's relating to sale, here it's relating to mortgage, okay? Like it's for securities that you are getting. We keep some security under mortgage, right? So it is relating to that. So you need to remember that it is coming under chapter 3 also, it is coming under chapter 4 also, for sale, for mortgage. Same concept, same philosophy, just that it is for the sale of the property, it is for the security that we are having. Okay, so what is marshalling? Anyone, any idea? Have you read this concept before? What is marshalling? Rachna?
No idea.
Okay. Anyone?
If you ask in Bangalore, people aware about this field marshals.
Yeah, so this is a different concept. It is rule of marshalling, and it is given under these two sections that we need to remember, 56 and 81. And how are these two concepts different? Right, so rule of marshalling. What is marshalling? It basically means arranging things, systematizing something, or regulate things, which mean the things arranged in a proper manner or order. Okay, that we need to organize or we need to arrange things in a certain given order. That means things are not in their proper order. All right, and we accordingly need to arrange it in a proper order. So why is that necessary? Right, the question comes, why is that necessary? What do we need to arrange in a proper order? So it is, yeah, when is it necessary, Rachna?
Your voice is breaking, ma'am. Couldn't hear properly.
Okay, voice is breaking. Is it actually power cut? Is it clear now or still breaking?
It is clear to me, ma'am.
Okay. Rachna, is it breaking only for you or how is it? Are you able to hear Rachna properly?
Now, okay, ma'am.
All right. So you can tell if it breaks again, okay? So rule of marshalling, that means that we want to arrange some things in a proper order or we want to regulate some things. Now, why is that necessary or what are we arranging in a proper order? All right. So this is marshalling. Like we see this kind of questions sometimes there is this proper order, what would come after this, right? We need to arrange some things in a proper order, right? Maybe something which is given like, okay, fine, under transfer of property, there are different modes of alienating property. There are different modes of transferring property. So you may be asked that arrange them in their proper order. That means you need to mention what is given under chapter 3, what is given under chapter 4, 5. Accordingly, you need to arrange in a certain given order. So just like how we have 1, 2, 3, 4, 5, in a proper order, in some given sequence, we need to arrange. That is nothing but the rule of marshalling. What are we arranging now, and where is this provision given? It is given under two sections, 56 and 81. 56 is relating to marshalling by subsequent purchaser. We know under different transactions, there are different parties involved, right? So in where is purchaser coming? Obviously, it's in the sale transaction. There will be buyer and there would be the purchaser, right? Buyer or the purchaser, and on another side, there would be seller. So when we say marshalling by subsequent purchaser, that means someone who has bought the property, subsequent as in subsequently he has bought the property. Before that, something else happened with the property, right? So marshalling by subsequent purchaser is given under section 56, which is relating to sale. Same marshalling of securities is given under section 81, that is relating to mortgage, because in mortgage we have securities, right? We want to keep some security because we are giving money to the other person, right? So in that case, marshalling of securities, mortgage, relating to mortgage. So you need to remember there are two sections, 56, marshalling by subsequent purchaser. When we hear the word purchaser, we understand it's relating to sale. And 81 is marshalling securities. When we hear the word securities, it's connected with mortgage. Now we'll understand what these two concepts are all about with the help of an example. Mayola, is my voice breaking?
Yes, ma'am. In between, it breaks.
In between, is it? One second, I'll just change the connection. Can you hear me now?